Isabella wears black velvet because the church requires mourning dress for annulment petitioners. She is 23. Her husband is 47. They have been married for 6 years. She has spent 4 of those years trying to leave. The chamber is smaller than she expected. Stone walls. A single window, narrow, letting in cold morning light. 3 chairs behind a heavy oak table. 3 men. Bishops, all of them. The one in the center is older, his vestments crimson and gold. He does not look at her when she enters. To his left, a scribe. Younger, maybe 30, with ink-stained fingers and a ledger already open. To his right, another bishop, this one with a face like carved stone. And beside the door, 2 women, older, dressed in black wool. They stand with their hands folded, faces expressionless. Isabella has never seen them before. The central bishop gestures to a chair in front of the table. "You may sit." Isabella sits. Her hands are shaking. She clasps them in her lap. "You have petitioned this court," the bishop says, reading from a document, "for annulment of your marriage to Lord Giacomo of Ferrara on the grounds of non-consummation. Is this correct?" "Yes, your grace. And you understand that such a claim requires verification." Isabella's throat tightens. Yes. The bishop sets down the document. "Canon law is clear. A marriage cannot be dissolved on the claim of non-consummation without evidence. Your testimony is insufficient. Your husband contests your claim. He states the marriage was consummated on the wedding night and on numerous occasions thereafter." "He is lying," Isabella says. "Then you will prove it." The 2 women step forward. Isabella realizes, too late, what they are here to do. In medieval Europe, marriage was not a contract between 2 people. It was a sacrament, blessed by God, witnessed by the church, and, according to canon law, indissoluble, except in cases of non-consummation. If a marriage had never been physically completed, it could be annulled, voided, as if it had never existed. The woman could return to her family. The man could remarry. The alliance could be undone without sin. But annulment was not granted on request. It required proof. And proof, in a world where a woman's word held no legal weight against a man's, meant something else entirely. When Isabella of Arezzo married Giacomo of Ferrara in 1347, the treaty was political. Her father needed military support. Giacomo needed legitimacy. The marriage was arranged, blessed, and recorded. Isabella was 17. Giacomo was 41. He was also, she would learn within the first month, incapable. Age, illness, injury, she never knew the cause. But he could not consummate the marriage. He tried, he failed, and after 6 months, he stopped trying. For 4 years, Isabella lived in his household. She managed his estate. She attended court. She played the role of wife. But she was not a wife. She was a legal fiction. When her father died and the military alliance dissolved, Isabella saw an opportunity. She petitioned the ecclesiastical court for annulment. She had witnesses, servants who could testify that she and Giacomo slept in separate chambers. She had evidence, no children, no pregnancy, no signs of marital relations. She thought it would be enough. But Giacomo contested. He claimed the marriage was valid, consummated, and ongoing. He accused her of lying, of seeking annulment to remarry, of inventing non-consummation to escape her vows. The church could not decide based on competing testimonies. So the church did what it always did when words were insufficient. It demanded the body as evidence. The law was written in the decretals of Pope Gregory IX. A woman seeking annulment on grounds of non-consummation must submit to physical examination by sworn matrons of good character, in the presence of ecclesiastical judges, to determine whether her virginity remained intact. If the examination confirmed virginity, the annulment could proceed. If it did not, the petition was denied. The woman was deemed a liar. She would be returned to her husband. In some cases, she would be fined. In others, punished for bearing false witness before the church. The examination was not optional. Refusal to submit was interpreted as admission of guilt. The annulment would be denied immediately. The woman would lose her chance at freedom. The matrons were chosen by the court. 2, sometimes 3, usually midwives, experienced in matters of anatomy and childbirth. They swore oaths before God to conduct the examination honestly, to report their findings truthfully, to allow neither bribery nor sentiment to influence their judgment. The judges did not conduct the examination themselves. That would be unseemly. But they observed, they recorded, they ensured the procedure followed protocol. The examination took place in a private chamber within the episcopal court. The woman was required to disrobe, to position herself as instructed, to allow the matrons to inspect, probe, measure. to submit to questions, to answer truthfully under oath. The matrons would determine three things: whether the hymen was intact, whether there were signs of habitual penetration, and whether the woman's body showed evidence of attempts at consummation that had failed. Their findings were reported to the judges. The scribe recorded every word. The document was signed, sealed, and filed. The woman's body became a legal record. Her flesh, translated into Latin. Her anatomy, catalogued in ecclesiastical archives. And if the examination supported her claim, she might be granted freedom. If it did not, she belonged to her husband until death. The matrons approach. One is gray-haired, perhaps 60. The other younger, maybe 40, with calloused hands and a face that reveals nothing. Stand, the elder matron says. Isabella stands. Her legs are unsteady. You will remove your clothing. Isabella's hands move to the laces of her gown. She fumbles. The room is cold. The judges are watching. Not directly. They look at their documents, at the scribe's ledger, at the window, but they are present. She can feel their attention like weight. The gown falls. The underskirt. The shift. She is naked. Step forward, the elder matron says. Arms at your sides. Isabella obeys. The matrons circle her, inspecting. The younger one touches her abdomen, presses gently, checking for signs of pregnancy. She finds none. She inspects Isabella's breasts. Nothing. No swelling. No changes. Turn around. Isabella turns. The elder matron runs her hands down Isabella's spine, checking for bruising, for marks. Anything that might indicate violence or resistance. She finds nothing. Lie on the table. There is a wooden table against the wall, covered with a linen sheet. Isabella walks to it, climbs onto it. The wood is cold against her back. Bend your knees. Place your feet flat. Isabella does. She stares at the ceiling. Stone. Vaulted. There are cracks in the mortar. The younger matron moves between her legs. Isabella closes her eyes. Spread wider. Isabella's breath catches. She spreads her legs. The matron's hands are rough, clinical. She palpates the outer anatomy first, checking for abnormalities, for signs of damage, for anything that would indicate repeated attempts at penetration. Then the internal examination begins. Isabella gasps. The matron's fingers are cold, invasive. She probes, measures. The pain is sharp. Isabella grips the edge of the table. The hymen is intact, the younger matron says. Her voice is flat, reporting a fact. No signs of tearing, no evidence of penetration. The elder matron leans forward. Let me verify. The examination repeats. Slower this time, more thorough. Isabella bites her lip. She tastes blood. Confirmed, the elder matron says. The hymen is intact. There are no signs of habitual marital relations. The anatomy is consistent with virginity. The scribe's quill scratches parchment. One of the judges speaks for the first time since the examination began. Are there signs of attempted penetration, bruising, inflammation? The younger matron examines again. Minimal. Old scarring. Consistent with failed attempts, not completed acts. Noted, the judge says to the scribe. The scribe writes. You may dress, the elder matron says. Isabella sits up slowly. Her hands shake as she reaches for her shift. She dresses quickly, clumsily. The judges do not watch. They are conferring in low voices. The scribe continues writing. When Isabella is clothed, the central judge looks at her for the first time. The examination confirms your claim, he says. The marriage was not consummated. The annulment petition will proceed to the next phase of inquiry. You will remain in the custody of the court pending final judgment. You are dismissed. Isabella stands. She walks to the door. Her legs barely hold her. She does not cry until she is outside. The annulment examination was not unique to Isabella. Across Catholic Europe, the protocol repeated. In France, England, Italy, the German states, Spain, any woman seeking annulment on grounds of non-consummation faced the same procedure. The practice was codified in canon law, standardized, taught to bishops and ecclesiastical judges as part of their training. The matrons were professionals, midwives, healers, women with anatomical knowledge who could testify under oath. The examinations were documented in ecclesiastical court records. Hundreds of cases, thousands, filed in cathedral archives, transcribed in Latin, preserved for centuries. In 1318, Lady Marguerite of Burgundy sought annulment from her husband, a count who had become impotent after a battlefield injury. The examination confirmed her virginity. The annulment was granted. She remarried within a year. In 1402, A merchant's daughter in Florence petitioned for annulment after 3 years of unconsummated marriage. The examination revealed old scarring, evidence of attempts but not completion. The annulment was granted. Her husband was ordered to return her dowry. In 1461, a noblewoman in England sought annulment. The examination found her hymen intact, but it also found evidence of pregnancy. She had lied. The annulment was denied. She was returned to her husband and fined for perjury. The court never investigated who had fathered the child. The system worked because it was legalistic, procedural. The body could not lie. Flesh was evidence. And evidence, properly documented, could override a husband's testimony. But the system also failed. Some women were examined and found intact, but were denied annulment anyway because the judges doubted the matrons. Some were examined multiple times, by different matrons, until the court was satisfied. Some endured examinations that were not merely clinical but punitive, conducted with unnecessary roughness, prolonged beyond medical necessity, designed to humiliate. And some women never petitioned at all, because they knew the examination was required, because they could not bear the thought of it, because remaining trapped in a failed marriage was preferable to submitting their bodies to strangers in a courtroom. The examination was the price of freedom, and the church set the price high, for women who could pay it, who could endure the humiliation, the pain, the violation of being reduced to anatomical evidence. Annulment was possible. For those who could not, marriage was a cage without a key. 3 weeks later, Isabella is summoned again. The chamber is different this time, larger, more formal, 5 judges instead of 3. The Archbishop of Florence is present, seated at the center, his vestments white and gold. This is the final hearing. Giacomo is here. He sits across the room, flanked by his own advocates, 2 priests who have argued, in written briefs filed with the court, that Isabella is lying, that the marriage was consummated, that she seeks annulment to marry another man, a younger man, a man her father had once considered as a match before choosing Giacomo. It is not true, but it is in the record, and the record is what matters. The Archbishop does not waste time. The initial examination has been reviewed, he says. The findings were clear. The petitioner's virginity is intact. However, new testimony has been introduced. He gestures to one of Giacomo's advocates, who stands and reads from a document. Lord Giacomo submits that the petitioner may have preserved her virginity through deliberate resistance, that she refused to submit to her marital duties, that her intact state is not evidence of his failure but of her defiance. Isabella's hands clench. That is, you will speak when addressed, the Archbishop says. The advocate continues. Canon law permits annulment only when non-consummation is due to incapacity, not refusal. If the wife has actively prevented consummation, the marriage remains valid. The Archbishop looks at Isabella. You will be examined again. This time, the court requires additional verification. The matrons will assess not only your physical state but whether there is evidence of resistance, scarring, damage, signs that you prevented consummation through force. Isabella feels the room tilt. I did not. The examination will determine the truth. The matrons enter. The same 2 women. They do not look at her. They have done this before. They will do it again. They are instruments of the court. Disrobe, the elder matron says. Isabella's hands shake as she removes her gown. This time, she is faster. She has learned the procedure. She knows resistance is futile. Lie on the table. She lies down. The wood is cold. The ceiling is the same. Vaulted stone. Cracked mortar. The examination begins. But this time, it is different. The matrons are looking for something specific. Evidence of resistance. They check for bruising on her thighs. For scarring around the entry. For any sign that she fought, that she clenched, that she prevented entry through physical force. The younger matron presses harder. Isabella gasps. The pain is worse than before. Any signs? One of the judges asks. Minimal scarring, the elder matron reports. Old, consistent with failed attempts. But no evidence of recent resistance. No bruising. No tearing from forceful prevention. Could she have used other methods? Devices? Obstruction? The matrons confer. They examine again, more invasively. Isabella stares at the ceiling. She counts the cracks. 12, 13, 14. No evidence of foreign objects, the younger matron says. No signs of artificial obstruction. The anatomy is consistent with virginity preserved through lack of penetration, not through active prevention. The scribe writes. The judges confer in whispers. The examination is conclusive, the Archbishop finally says. The marriage was not consummated. Lord Giacomo's claim is rejected. The annulment is granted. Isabella is dismissed. She walks out of the chamber. She is free, but she will never forget the table, the cold wood, the invasive hands, the counting of cracks in the ceiling. Freedom came with a price, and she paid it in flesh. The annulment examination began to fade in the 16th century, not because the Church decided it was wrong, but because the Reformation fractured ecclesiastical authority. In Protestant regions, annulment disappeared entirely. Marriage became a civil contract, dissolvable through secular courts. Physical examination was no longer required because the concept of sacramental indissolubility no longer applied. In Catholic regions, the practice continued but became inconsistent. Some courts still required examination. Others accepted testimony from physicians who had examined the woman privately. Still others allowed women to swear oaths before God and accepted their word, if they were noblewomen of sufficient rank. The last recorded annulment examination in France occurred in 1632. A merchant's wife, married for 9 years, sought annulment on grounds of her husband's impotence. The court ordered examination. 2 matrons confirmed her virginity. The annulment was granted. The records were filed. The case was unremarkable. By the 18th century, the practice had all but vanished. Annulment became rarer. Legal separations became more common. Women seeking to leave marriages pursued other avenues: convents, accusations of cruelty, quiet arrangements brokered by families. But the records remained. Hundreds of cases, filed in ecclesiastical archives across Europe, written in Latin, catalogued by date, by diocese, by outcome. Modern historians discovered them in the 1970s and 1980s. Researchers combing through medieval court records for data on marriage patterns, property disputes, social structures. They found the examination protocols, the sworn testimonies of matrons, the judges' deliberations, the women's names: Isabella of Arezzo, Marguerite of Burgundy, hundreds of others. Women who sought freedom and paid for it with their bodies. Women whose anatomy was transcribed into legal documents. Women whose most intimate moments were preserved in ecclesiastical Latin and filed in stone vaults. The examinations were not secret. They were not hidden. They were law, documented, official, sanctioned by the highest authorities of the Church. The horror was not that it happened in darkness. The horror was that it happened in daylight, in courts, before judges, recorded by scribes, preserved in archives where scholars would later find them and note, with academic detachment, this was the procedure. The women who endured it left no commentary. Their voices are not in the records. The documents catalogue their bodies, not their suffering. The Latin describes anatomy, not trauma. What remains are the case files, the matron's reports, the judge's rulings, and the verdict, written at the bottom of each successful petition: matrimonium nunquam consummatum, annulatio concessa, marriage never consummated, annulment granted, freedom, written in Latin, purchased with flesh, filed in stone vaults where it would wait for centuries before anyone asked what it cost. The law does not ask what it costs. It only asks what it requires. The annulment examination was not designed to humiliate women. It was designed to determine truth, to separate legitimate claims from fraudulent ones, to protect the sanctity of marriage while allowing for rare, justified exceptions. The Church did not see it as violation. The Church saw it as verification. Because in a legal system where a woman's testimony held no weight, where her word could not override a man's, where proof required something more than speech, the body became the only reliable witness. And so the body was interrogated, examined, measured, translated into evidence, filed as documentation. The women who submitted to it were not seen as victims. They were seen as petitioners, as legal actors exercising the only avenue available to them, as participants in a process that, however invasive, offered a possibility their mothers and grandmothers never had: escape. The system gave them a choice: endure the examination, or remain married. Submit to strangers in a courtroom or submit to a husband for life. It was not a fair choice, but it was a choice. And in a world where women had few choices at all, some took it. The horror was not that the system existed. The horror was that it was necessary. That the only way a woman could prove her marriage had never been real was to prove her body had never been touched. That freedom required submission. That escape required violation. That the law demanded the same thing it claimed to protect. The examination tables are gone. The matrons are dead. The judges are dust. But the records remain, filed in archives, written in Latin, preserved in stone vaults. And if you read them, you will find the names, the dates, the findings, and at the bottom of each successful case, the words that meant freedom. Annulatio concessa, granted.